Good afternoon. My name is Mary Cartharis, and I am the Acting Chief Policy Officer and Director for International Affairs of the Office of Policy and International Affairs. This is our first USPTO hour, but we hope it'll be one of many because we have a lot of international developments that we'd like to share with you. Today's session, though, is going to focus on the World Intellectual Property Organization, commonly referred to as WIPO. WIPO is a UN agency that specializes in the promotion and protection of intellectual property rights. Currently, there are 194 members to the WIPO, hailing from all across the globe. Based in Geneva, Switzerland, WIPO hosts a variety of different services for the IP community, most notably its international filing services that allow patent applicants to seek protection worldwide. WIPO is also an important forum for the discussion of emerging IP events and issues, as well as for norm setting and developing treaties. I would like to begin this program by introducing our WIPO team, and I'd like to start with the leader of the WIPO team, David Girk.
Thanks, Mary. As you said, my name is David Girk. I'm the Acting Deputy Chief Policy Officer for Creative Works and Global Outreach. I'll turn to the team.
Hi, I'm Andrew Moore. I'm an attorney advisor in the Office of Policy and International Affairs on the copyright team here.
Good afternoon. My name is Laura Hamill, and I am the senior level intellectual property attorney for Global Outreach.
Hello, my name is Gordon Klansnick, and I am a patent attorney on the patent team also at OPIA. Thank you.
Thank you. I'd also like to introduce Skip Thomas, who is not here in the panel with us, but he's behind the scenes helping us through this process. And a real shout out to Skip for leading the development of this USPTO hour. So I wanted to give a brief overview of the Office of Policy and International Affairs because most people don't really know what we do. So first, I'd like to explain that we are the IP policy hub for the USPTO. We develop domestic and international intellectual property policy. We advise senior officials within the PTO and within the administration on IP policy. And we also actively represent the United States in a lot of different fora around the world, including the World Intellectual Property Organization. And that's what we're going to focus on today. We cover IP disciplines from patents, copyright, trademark enforcement, global outreach, as well as we have a specialized team on China. We also have our Global Intellectual Property Academy, in which we train people on best practices for IP matters. Last year in 2024, we trained over 7,500 different people across the globe. And I also want to highlight our IP Attaché program, which is our eyes and ears across the globe that also assist stakeholders in addressing IP concerns. Another interesting statistic is in 2024, our IP Attachés assisted over 6,500 stakeholders. So we also have cross-discipline regional teams that we can see on the presentation here. And we also noted our attachés, which you can see the global footprint by looking at the navy dot. And that includes attachés in Brussels, Geneva, in China, in India, in Southeast Asia, in South Africa, and in South America as well. With that, I'd like to turn it over to Dave, who's going to give a brief overview of the WIPO organization.
Thank you very much, Mary. WIPO was established in 1967 under the WIPO Convention, and its mandate is to promote the protection of intellectual property throughout the world. For most out there who think of WIPO, probably most familiar with things like the PCT system for patents, Madrid for trademarks, or the Hague system for industrial design or design patent rights. Also, a high-profile event like the WIPO Assemblies might be something you're familiar with, and we'll get into those a little bit later. I'm going to talk a little bit about some of the organization of WIPO, but I do want to highlight, as you mentioned, the team, Mary, that the USPTO leads U.S. engagement in WIPO IP policy discussions in the various forums. Additionally, these treaties such as PCT, Hague, we'll talk a little bit about the Design Law Treaty, which was a recent treaty, these normative negotiations, that is also discussions that take place at WIPO that our team is proud to represent the U.S. government in those discussions. So WIPO can be thought of at a high level to have governing bodies, negotiating bodies, and some other bodies. Let's start with the governing bodies. The WIPO General Assembly is the highest level, if you will, and decision-making body. Some of the issues that they take stock of and take decisions on include budget concerns and the Program and Budget Committee's work. They also are the decision-making body to give direction and also take final decision on what's proposed coming out of the various permanent and standing committees, and I'll talk a little bit more about those. And then, as I mentioned again, they make the decision whether to convene a diplomatic conference. There's a topic where a treaty might be ripe to pursue. Then established bodies also have unions, and those are the decision-making bodies for various agreements. So, for example, the Paris Convention, Berne Agreement, PCT, Hague, Madrid, all have various unions that take decisions when rules are proposed or changes, updates need to be made. Finally, the WIPO Coordination Committee deals with a lot of the administrative issues from human resource issues. If WIPO is going to enter into agreements with perhaps other UN agencies or other bodies, and then in helping to take a decision on the election of the Director General. There's also WIPO Conference, but we'll leave that for another time. It's a rather technical body. Moving on to the negotiating bodies. As mentioned, there's sort of two categories of committees. We have the standing committees and the permanent committees. Standing committees consist of the various subject matters you might be familiar with from IP. So there's the Standing Committee on the Law of Patents, the Standing Committee on the Law of Trademarks, Industrial Design, and Geographical Indications. There's the Standing Committee on Copyright and Related Rights, and finally, Committee on WIPO Standards, which deals with some of the more technical areas of WIPO's work. Under the grouping of permanent committees, we have budget issues under the PBC. We also deal with issues like IP and development at the Committee on Development and Intellectual Property, or CDIP. And you will hear a little bit more today, IGC, and that stands for the Intergovernmental Committee on IP and Genetic Resources, Traditional Knowledge, and Folklore. We'll just refer to that as IGC moving forward. And also we tackle issues dealing with enforcement in ACE, the Advisory Committee on Enforcement. Now, moving on to perhaps what people are most interested in, the subject matter, the IP policy, the IP discussions, cover subject matter of patents, industrial designs, trademarks and GIs, copyright, and then all brought together through administration. And the team's going to talk more about those. So I'm going to, for time purposes, stop there and hand it back to Mary so they can dive into those a little bit more.
Thanks, Dave, for that great overview of WIPO. And obviously turning to some of the key substantive issues, I think we'll start with patents. We are fortunate to be joined by Gordon, who is an experienced and seasoned patent attorney and often represents the U.S. at meetings before WIPO. So, Gordon, back in 2024, WIPO adopted a new treaty on genetic resources and associated traditional knowledge. This requires patent applicants to disclose the source and origin of genetic resources. Can you share with us the basic tenets of that treaty?
Absolutely, Mary. So this treaty arose from the work out of one of the permanent committees, as Dave mentioned, the IGC, and thank you for allowing us to use just IGC. The full name is a mouthful. The WIPO states, pursuant to a direction by the General Assembly, the WIPO states convened a diplomatic conference and then negotiated and adopted the treaty that mandates patent applicants disclose the origin of a genetic resource, or a GR, or associated traditional knowledge, ATK, in certain circumstances. Now, it's known as the GR-ATK Treaty, so Genetic Resources and Associated Traditional Knowledge. And it's important to keep in mind that the treaty would only apply to countries or jurisdictions that have acceded to or ratified the treaty. It's also important to keep in mind that the disclosure requirement is triggered where a claimed invention is based on, and that's the key term, based on a genetic resource or associated traditional knowledge as determined by a two-part test, this two-part test. The first part is that the genetic resource or associated traditional knowledge must have been necessary for the claimed invention. And then the second part of this test is that the claimed invention must depend on the specific properties of the genetic resource or associated traditional knowledge. And that's...
Great. No, thanks for that. So can you please explain what the status of that treaty is? Is it in effect, and how does it go into effect?
Thanks, Mary. Yeah, absolutely. So under its terms, the GRATK treaty will go and enter into force 3 months after it's ratified or acceded to by 15 eligible parties. It was open for a signature for 1 year after its adoption, so until this past May of 2025. But importantly, it's not currently in force because only 2 countries have ratified or acceded to it.
I wonder if you could explain how this new treaty interacts with the existing PCT framework.
Also a very excellent question. So let's just take a step back and look at the treaty itself. And with respect to the PCT framework, the GRATK treaty includes an article, specifically Article 7, that states, and I'm going to quote, and I'm going to read from my notes here, "This treaty shall be implemented in a mutually supportive manner with other international agreements relevant to this treaty," close quote. And that includes 2 footnotes. And so these 2 footnotes are also important to keep in mind when looking at this article. The first footnote sets forth the procedure for contracting parties to the GRATK treaty to propose amendments to the PCT framework. And then the second footnote specifies that the GRATK treaty does not derogate from or modify any other international agreement, such as the PCT, although the PCT is not called out in that footnote. So that's where the interaction of the PCT and the GRATK treaty comes about.
Okay. Well, thanks. I know a lot of people are interested in what is the U.S. Position on this treaty and whether there's something we're going to adopt.
I don't believe that position has been firmly established. I understand that, again, only 2 countries have ratified or acceded to it. The United States did not sign the treaty, is not a signatory to the treaty. Of course, that period is now past. But with respect to the PCT aspect, this administration and the United States does have a fairly firm and clear position. And Acting Director Stewart mentioned that she set forth in her remarks at the General Assembly. First, we need to keep in mind that the international filing and registration systems, those 3 systems that Dave mentioned earlier, including the PCT, the Hague and Madrid, others ones, the international filing and registration services administered by WIPO form the backbone of the organization and must be continued to be improved and streamlined. And specifically for the PCT system, for it to remain an effective tool for patent applicants, the system cannot add requirements such as the disclosure of traditional knowledge and genetic resources that do not relate to the patentability of inventions. And so the United States remains committed to strong and effective systems that serve the interests of stakeholders in a global intellectual property ecosystem and opposes importing the disclosure requirements of the GRATK treaty into the Patent Cooperation Treaty.
Thanks so much for that. Speaking of robust IP systems, I'd like to ask you a question about patent law harmonization. We all know that substantive patent law harmonization has been a recurring but very difficult issue. Do you see any momentum on this topic at WIPO?
Well, that's a very difficult question. Again, for this, let's start and back up and start with a little bit of a history.
I just want to really challenge you.
That's absolutely every day.
Easy ones.
So we're going to start with a little bit of a history lesson here to help understand where we are with respect to substantive patent law harmonization. So the General Assembly created the Standing Committee on the Law of Patents, SCP, Dave mentioned earlier, in 1998 with the mandate to serve as the forum to discuss issues facilitate coordination, and provide guidance concerning the international development of the law of patents, including harmonization of national laws and procedures. So the committee's work was successful initially, and the committee's work led to the Patent Law Treaty, or the PLT, that relates to formal requirements for patent applications, and that was adopted in 2000. So very quickly after that committee was formed, the committee began discussing a draft substantive patent law treaty in 2001. But those talks were paused about 5 years later due to substantial differences of opinion. Now, the SCP still exists, but without prejudice to that mandate, the SCP now confines its work to fact-finding and not harmonization. So the work and discussions at WIPO regarding substantive patent law harmonization are non-normative, meaning they're unlikely at the current time to lead to a diplomatic conference, and are unlikely to lead to harmonization, at least in the near future.
Thanks, but moving forward, let's talk a little bit about some of the key issues facing the patent system, and obviously on everyone's mind is artificial intelligence. So here there's potentially an opportunity to really delve into the intersection of AI and IP rights. I'd like to ask you, what work is WIPO doing to address the question of whether an AI system can be named as an inventor?
Everybody loves talking about AI, so absolutely, the WIPO is doing a fair amount of work in this area, and obviously the United States is actively engaged in all of that work. And there are a couple different forums regarding artificial intelligence where this work is going on, including the WIPO Conversation on Intellectual Property and Frontier Technologies, and that's just a conversation. It's not one of those committees that we were mentioning earlier. But also the Standing Committee on Patents. So the conversation discusses AI, but also other frontier technologies. So it's not just limited to AI, but AI certainly is part of those conversations. But the SCP in particular has been discussing various aspects of artificial intelligence, including the legal and policy options in the substantive areas of patent law, such as inventorship, but also the substantive patentability requirements and what those look like in this world that involves AI. And then separately, the SCP has looked at other aspects, other related issues to those two, and it's such as the use of artificial intelligence in patent examination and tools used by examiners and offices to facilitate their office management and the processing of a patent applications.
Well, it's good to see there's a lot of discussion at WIPO on some of these emerging technology issues. We understand that, countries around the globe are adopting different practices. Do you think there's a role for WIPO as a forum for helping countries come to a common understanding or agreement on these issues?
No, yes, absolutely. I mean, even if it doesn't lead towards normative work, the fact-finding work, including the resources and the reports that are generated and the forums that facilitate these discussions, and that lead to further policy discussions amongst the member states. They help all member states understand each other's laws and practices, and that feeds into the work, the global work that we do here in terms of looking at other jurisdictions. And this understanding and these conversations and this fact-finding can reveal convergences and similarities across the globe while preserving national sovereignty regarding some of these, frankly, difficult but also cutting-edge issues while they're still being fleshed out.
Yeah, no, thanks, Gordon. I think you raise excellent points. Important that we don't have to always have a treaty to have a common understanding of practices, but also how important it is when we do explore what other countries are doing. We learn a lot by hearing as we shape our own domestic policies. So thanks for highlighting that. Another important issue is standard essential patents in today's digital economy. What is WIPO's role in this increasingly complex SEP FRAND issue?
No, excellent. Also, another difficult and thorny topic that WIPO has delved into. And there's two aspects to WIPO's work here. There's first, there are the discussions that are being held at the SCP and other various forums. Like some of these other issues, the SCP has been discussing various aspects of SCPs, standard essential patents, and including FRAND terms, the fair, reasonable, and non-discriminatory licensing related type issues. There's also, it's not just limited to the SCP. There's an upcoming symposium on SCPs later this month, for example, that includes topics such as the economics of FRAND determinations. I'm going to read from my notes here. Economics of FRAND determination, global judicial developments in SCP litigation, alternative dispute resolution, the role of government's competition law, and so on and so forth. So there's a lot of different venues and a lot of different abilities for member states and also other interested parties to have these discussions at WIPO. And that's just one aspect. The other big aspect of WIPO's work for SCPs, standard essential patents, and particularly FRAND type issues, is WIPO has an arbitration and mediation center, and that can provide an alternative to court litigation of IP and technology disputes, and provides mediation and arbitration services. And disputes regarding standard essential patents often arise from cross-border patent portfolios spanning multiple jurisdictions. There's a lot of patents, there's a lot of issues, there's a lot of technology, there's a lot of accused devices, and that can be well suited for resolution using the services provided by the WIPO's Arbitration and Mediation Center.
Yeah, well, that's really great. I know there's been a recent uptick in the use of the Arbitration and Mediation Center at WIPO, so we're following those developments closely, and maybe this will be a good forum for those disputes to be resolved. So one final issue before we close out the patent session is I've heard a lot of stakeholders express concern with the costs and difficulty of recording assignments globally. So Gordon, can you tell us, how is WIPO working to address this issue?
Well, as we've discussed this issue with stakeholders and our global trading partners, it is apparent that it's an area of interest and one that's worth exploring. And we think that WIPO is well positioned to facilitate these discussions regarding potentially reducing the friction of recording assignments relating to patent families and portfolios that span one or more jurisdictions. But the work is frankly just in its initial stages at this point.
Well, we look forward to this progressing because I know it's of vital importance to our stakeholders. The next topic that we wanted to focus on is WIPO's work with respect to industrial designs, which are ornamental aspects of a functional object. So Gordon also, in addition to being our patent expert, is our expert on industrial designs. So last year, 2024 was a real banner year for WIPO. As was mentioned by Dave and important, there was the Treaty on Genetic Resources and associated traditional knowledge. But there was also a design law treaty that was adopted by WIPO, and this is similar to the PLT and the Singapore TLT treaty, which reduces the formalities necessary for applications. So Gordon, can you share with us what are some of the real benefits and advantages of the recently concluded DLT?
No, absolutely. Again, and I just will say that it was an honor and a privilege that Dave and I were able to represent the United States at the diplomatic conference in Riyadh last November. And it was a lot of very late nights, but we think it was a successful outcome given where we were going into the diplomatic conference. So as you mentioned, it's a formalities treaty, so it's not a substantive design law treaty for industrial designs, and it completes the PLT and the STLT. So those three should be viewed sort of together. But actually the RDLT borrows some provisions from each of those two other treaties and echoes provisions. And it's intended to harmonize and streamline the formal requirements for industrial designs, and includes things like what's needed to obtain a filing date what can be included in the content of an application, as well as relief provisions. For example, for missing a filing a date, or not or those relating to extensions of time, continued processing, reinstatement of rights. There's quite a number of provisions, but it also includes a provision that regarding a grace period for pre-filing disclosures, and that's something that the U.S. stakeholders had really sought very hard to be included. And so we were happy to see that reflected in the treaty.
They called it a crown jewel of the treaty.
Thank you, Dave. I don't know if your mic is on, but they have called it the crown jewel of the treaty. So, like the GRATK treaty, the RDLT, we adopted the name. The diplomatic conference adopted the name Riyadh on the last day. The RDLT will enter into force 3 months after it's ratified or acceded to by 15 eligible parties. So far, we're still working towards those 15.
That's great. Fantastic update. I just wanted to highlight that I know like I said, this was a banner year for WIPO, but both the RDLT and the treaty, the Genetic Resources and Traditional Knowledge Treaty, were both 20 years in the making. So international progress is very slow, but we are very fortunate that we had a successful conclusion with the RDLT. And I know that U.S. Is mostly in compliance with the provisions of the DLT, but just want to highlight that the real benefit is other countries to adopt this treaty, so that it'll be easier for our filers to obtain protection abroad. So the next topic, once again, we see the impact of technology, how it's challenging the boundaries of IP law for industrial designs. The question of the day is how to adequately protect these digital designs, such as graphical user interfaces. Can you fill us in, Gordon, on the developments at WIPO to protect these types of digital designs?
Sure. And again, this is the work of another standing committee, no longer the SCP. It's now the SCT, which again was on one of Dave's slides earlier. It stands for the Standing Committee on the Law of Trademarks, Industrial Designs, and Geographical Indications. Its recent work has involved a number of different things, but including a joint recommendation regarding the protection of graphical user interfaces, or GUIs. Because it's a recommendation, it's important to keep in mind this is not normative work, but it's a sort of a best practice for jurisdictions around the world to follow, and then make it easier for U.S. applicants and U.S. stakeholders to obtain rights worldwide. But this again ties to something that Mary mentioned and that I mentioned earlier about this international work and our international teams. Is those teams have their ear to the ground through the attachés, through our regional work, and so we can understand what convergences exist, and that sort of led to this GUI recommendation. Just monitoring those legal developments, it help view what's going on in the world with the protection of digital designs.
Thanks, Gordon. And unlike treaty making, which takes about 20 years, it's nice to have these other options like joint recommendations that do provide some type of soft law, but yet still have meaningful progress and do set the stage for what the global standard is in this area. So very valuable work being done at WIPO. And finally, I'd like to turn to the Hague system for the protection of industrial designs. And so the Hague system is the corollary to the PCT system for patents. This is for industrial designs. And can you share any key updates on improving the Hague system?
Sure, and actually, I love talking about the Hague system, so we could turn this into a whole hour.
And so do I.
Yeah, absolutely. But I'll try and keep it short. Just as a quick reminder, the Hague system relates to a filing and registration system for industrial designs that's similar to, but not identical to, the PCT system for patents, and as well as the Madrid system for trademarks. The Hague system has really seen tremendous growth, especially since the United States joined in 2015. And notable recent accessions include, for example, Brazil and Saudi Arabia, just in the last couple of years. And there are even a number of countries currently in discussion with WIPOs regarding a session. It depends on who you talk to on that day and whether they're part of WIPO or not, but it's a good number. And this system continues to grow, and we're expecting a lot more growth. So although it doesn't have the reach of the PCT system just quite yet, it certainly is trending in that direction. So as part of the growth, it's important that, as we mentioned earlier, that the filing and registration systems, all of them at WIPO, are beneficial, meaning that they continue to they're self-sufficient. The fees that are generated pay for the costs of those systems. They're cost efficient for applicants as well, and then beneficial aside from the money issues for users and offices. And so the PTO benefits, the USPTO benefits, but also the users of the Hague system benefits, our stakeholders benefit. So our efforts are aimed at improving and streamlining the Hague system so that users can obtain intellectual property rights, specifically design rights, across the globe in an economical and straightforward manner. And next month, there's the Hague Working Group. That's one of those working groups that discusses this system. And of course, there's a PCT working group and a Madrid working group that discuss those other systems and how to update and how to modernize them. And we're looking at potential rule updates. We're looking at things like fees and other aspects of the system. But again, with that guiding light, that whatever we do needs to benefit the system, not just from a user standpoint and from an office standpoint, but also a financial standpoint of the system itself.
Well, thanks, Gordon. I know that Dave and I have a soft spot for the Hague system. I didn't know you were a member of that fan club, so welcome aboard. I think it's exciting to see we were here when we implemented the Hague system for the United States. A number of other key countries like Japan and China and Korea also joined the Hague, and so we're seeing tremendous growth in this area and also increased reliance on industrial designs being an important part of purchasing items. So it's a real commercial advantage for our stakeholders. So thanks again, Gordon, for all your valuable insights. I'm going to turn it over to Dave and Andrew to talk about developments at WIPO with respect to trademarks and copyright.
Thank you, Mary, and thanks, Gordon, for all those insights. We're going to stay within the SCT committee, but just switch topics here. So we're going to turn to trademarks and GIs. Andrew, leaving Hague, it seems logical to go to the Madrid system. And as Gordon mentioned, as the systems grow, one of the things we try and advance certainly is making sure the system stays effective and useful for stakeholders and learning from if there's any challenges to be addressed. Could you maybe talk about, as we have the Madrid working group coming up here later in September, can you please talk about any developments on that front?
Sure, Dave, thanks. So the Madrid system is WIPO's system for registering and managing trademarks worldwide. And one of the things under discussion at the SCT is Madrid modernization and specifically an issue called dependency. So in short, to obtain one of these international applications, you have to first file a basic application with a national or regional office before you can then file an international application using the Madrid system. Now, for the first 5 years, that international application is dependent on the basic registration. And if anything were to happen to that, say, it were canceled, that would impact the international application dependent on it, which, so if the basic one gets canceled, the international registration would also be terminated. And now, so discussions are underway about how or if to modernize that dependency requirement because of the fact that businesses and brands rely on that international protection. The United States has put forth a proposal to address this dependency issue that would give flexibility to member states and to have different national approaches. There could be, within the U.S. proposal, I think it ranges from maintaining the current dependency and basic mark requirements to everything to getting rid of both dependency and the basic mark entirely.
Well, great, and we'll look forward to those discussions continuing here later in September. Turning next to the next topic and talking about geographical indications and perhaps the Lisbon Agreement. I guess we could maybe look at this as maybe a bigger bucket of issues, geographical names. Can you talk about some of those issues? I know this comes up in in the news from time to time, and certainly an area that our trademark team spends a lot of time focusing on.
Sure, thanks. So within the SCT, there are geographical names come up in a variety of manners and work streams. So looking first to geographical indications. So the Lisbon Agreement covers geographical indications. The United States finds that these geographical indications can sometimes be problematic for domestic stakeholders, particularly the dairy industry, who rely on common names. So, for example, Asiago would be a geographical indication in the EU, but in the United States, it's a common name. So, European farmers, when they first migrated to the United States, brought with them the practices, and they continued to make the same cheeses, for example, that they made in Europe. And these cheeses, Asiago, Gorgonzola, became common names and are now produced in the United States and exported around the world. Restrictions on who can market under those names negatively affect U.S. stakeholders because it impacts their ability to market and export their goods around the world. And the United States, as I said, is not a member of the Lisbon Agreement and has no intention of joining the agreement unless amendments are made in order to incorporate trademarks into the agreement. Looking next to geographical names, there has been some proposals within the SCT to create an international notification instrument, which would provide automatic protection to nation brands. And now the automatic protection part of that has been a bit walked back. The U.S. does not support the nation brand proposal in that way because we find that these have been used in commerce and the trademark system has been adequate for those up till now.
Great, thanks for that recap. A lot of issues there bundled under this topic, and certainly complicated, and certainly an area for those interested to watch the Standing Committee on Trademarks, Industrial Designs, and Geographical Indications to see how those discussions develop. And of course, we're in the digital age, and we're probably past that into whatever we call this newest modern era, but there's always issues with new tech, internet, and those issues. Can you talk a little bit about that in relation to the trademarks and GI space and that area?
Sure, yeah. So I can talk about the domain space protection briefly. In short, there's been discussions underway regarding the incorporation of geographical indications into ICANN's Uniform Domain Name Dispute Resolution Policy, or UDRP, and that handles disputes involving trademarks and domain names. However, there hasn't been much progress on this so far, as there are a variety of different approaches regionally and nationally to geographical indications.
Great. Well, I'm going to ask you to maybe put away your trademark and GI cap and put your copyright hat, which is probably your favorite hat, given you're on that team. But first, Gordon talked about the distinctions, and Mary as well, between normative discussions as well as a little bit softer. Can you highlight any potential normative discussions or work streams that might be going on in the SCCR, the Copyright Focused Committee at WIPO?
Yeah, thanks, Dave. Within the SCCR, the Standing Committee on Copyright and Related Rights, there have been long-running discussions on a potential treaty for protecting broadcasting organizations and linear broadcast signals, specifically with respect to signal piracy. And now I think this won't come as a surprise given the conversations on the other treaties. Discussions have been going on for over 20 years. Progress has been slow, particularly because of changing market conditions and developments in the broadcast technology and also different regional practices. Currently, one of the major issues is whether or not this text should be limited to a kind of traditional broadcast that is so the broadcast of broadcasts that are available to a customer on a television or satellite or cable broadcasts available on a specific channel at a specific time, or whether there should be a new broad exclusive right created for these broadcasting organizations to cover on-demand streaming and catch-up TV. So that would be things available to a consumer on at a time and place that they choose, so via an app or a streaming service. And the U.S. has long maintained the position that this should be limited to the traditional broadcasts, while other countries have been vocally supportive of an expanded right.
Great. And we're usually talking in the WIPO context about convergence of rights and how different countries implement those. But there are also sometimes discussions arise about certain unique circumstances. I think often they're referred to as exceptions and limitations. Can you give us a little insight into those in the copyright space at WIPO?
I can. Thanks, Dave. So within the SECR, there have been discussions on exceptions and limitations to copyright protection. Some member states have been pushing strongly for new binding legal instruments that would establish new exceptions and limitations for a variety of purposes, from libraries and archives or educational institutions, museums, and things like that. The United States and other member countries also feel that the current legal framework has sufficient flexibilities that allow member states to adopt exceptions and limitations on a national basis as they see fit and as fits for their conditions. The U.S. has proposed a principles and objectives document on limitations and exceptions for libraries and archives, which would kind of provide outline about where these exceptions and limitations could be found. Alongside this work stream, WIPO has published a toolkit on preservation, which provides resources to policy experts and others who on exceptions and limitations and protections related to cultural heritage and preservation. And that is intended as the first in a series of similar toolkits to come out of WIPO.
Great, and you had to anticipate this last question based on our discussion in trademarks. So we got to ask something on the digital era and digital environment. So what can you highlight, or what would you highlight from the Standing Committee on Copyrights and Related Rights and other areas of WIPO with respect to copyright in the digital environment?
So within the SCCR, there have been discussions on falling into this bucket on copyright in the digital environment. And now this is a proposal within the SCCR, and it's a very broad topic. So there has been disagreement and discussion within the SCCR on what exactly falls in copyright in the digital environment and whether it should be a standing agenda item at all. One proposal has limited this discussion, or would limit this discussion to remuneration rights for authors and performers related to digital music streaming. The United States feels that this is focused more on, or that is too narrowly focused on marketplace and contractual issues that are outside the competency of the SCCR. So that is not a framing that we've been supportive of.
Great. Well, thanks for all those insights on trademarks and copyrights, Andrew. At this point, I'd like to turn to you, Laura, and talk a little bit about WIPO administration. And for the public to know, Laura does a great job. She helps lead our team in the representing the U.S. at the General Assembly and all that work. So she has very unique knowledge of these issues. So let's turn to the first one in that space, program and budget. Any organization, WIPO included, the policy direction on programming, as well as in particular how things are financed, obviously dictate outcomes. Can you talk a little bit about that work, please?
Absolutely, Dave, and thanks so much also for your kind words. At the outset, I'd like to just explain a little bit about how WIPO is funded. Unlike other UN organizations, the vast majority of WIPO's budget actually comes from user fees. These are paid by fees of the various international registration and filing systems that were discussed earlier by my colleagues. And in particular, the PCT, or the Patent Cooperation Treaty, accounts for the largest share of these fees. Specifically, specifically 75% of all of WIPO's income. These user fees are actually 96 to 97% of all of WIPO's income. The Madrid system also accounts for a significant amount of these fees as well. Just to give you an idea of what that budget looks like, in 2024, WIPO brought in over $500 million in user fees. And U.S. rights holders are actually a major source of these fees, as the U.S. is the largest user of the Madrid system and the second largest user of the PCT system. Assessed contributions really only comprise 3% of WIPO's budget, and these are paid by member states. So the reason that we're so focused on WIPO's budget is frankly because it's how our user fees are being spent. We spend a lot of time being actively engaged to ensure really good oversight over WIPO's budget and management, to ensure that these fees are being used prudently and in the best interests of our U.S. stakeholders. And we do this by actively engaging in discussions at WIPO's Program and Budget Committee meetings, including regarding WIPO's proposed biennial program of work and budget, which is also later discussed at the General Assembly as well.
Great, thanks for that insight. Just before we leave budget type issues, you'll hear the U.S. and some other delegations at WIPO, particularly at the PBC, the Program and Budget Committee, as well as the WIPO assemblies, talk about financial sustainability. What particularly does that mean in the context of WIPO, and maybe how might that impact users?
That's a really key concept for us, as you're well aware, in the PBC meetings, as well as in the General Assembly, as well as in a number of the other meetings that we are engaged in. As I mentioned earlier, PCT is really the big moneymaker for the organization, and Madrid also brings in a lot of money. However, the other unions are in the red, and PCT and Madrid fees have been used to finance these other unions' shortcomings. The Lisbon Union that Andrew discussed earlier has never been financially sustainable, and it is particularly concerning that PCT and Madrid fees, including those paid by U.S. filers, are being used to finance the system that harms other U.S. companies who are users of common names, particularly in the dairy industry space. Thus, the U.S. continues to demand at all of these WIPO meetings that all WIPO registration systems be moving in a direction of solvency and financial self-sustainability. We also continue to loudly highlight that PCT and Madrid filers cannot continue to be burdened with fees that fund other systems and aren't solvent and moving in that direction towards financial self-sustainability.
Great, thanks for that insight, Laura. Turning back to IGC, and since it's been a while since we've said the whole name, that's the Intergovernmental Committee on IP and Genetic Resources, Traditional Knowledge, and Folklore. Gordon described a lot of discussions in relation to that. And what role does the WIPO General Assembly or the assemblies have with respect to discussions in this area? Maybe you could talk a little bit about those issues.
Sure, and maybe at the outset, just to highlight that the IGC is, again, a permanent committee at WIPO that's focused upon text-based negotiations to finalize an agreement or agreements on international legal instruments for the protection of TK, which is traditional knowledge, traditional cultural expressions, TCEs, and genetic resources, or GRs. As mentioned by Gordon earlier, the work did result in the GR-ATK treaty in 2024. And so the General Assembly's role is really in directing further work. And at our recent General Assembly, the IGC's mandate was just renewed for the 2026-2027 biennium. And what that means is that the IGC can continue to work and to discuss the protection of GRs, TK, and TCEs. And specifically, these discussions will be spread over 3 sessions throughout that biennium. And during these discussions, the IGC's work will be based upon working methods involving an evidence-based approach with actual examples of national and regional experiences.
Great, thank you. And I think we've done a great job of holding up the reputation of government officials and governments using a lot of acronyms today. So we can continue that for sure. Turning to the last topic under administration, Probably the most high-profile event, the WIPO assemblies, where you gather all the member states. The General Assembly meets there. And on the margins of those meetings and discussions, many high-level officials from different governments use that opportunity to also have discussions. Can you talk a little bit about that? I know you and I were fortunate enough have several years represented with the team, the U.S., in those discussions. Can you please talk about those?
Absolutely, Dave. Yeah, it was a pleasure this past year to be there with you as well as Mary. And you can see a snapshot on the slide here showing the team with our leaders, as well as our IP attaché who covers WIPO, Marina Lamb, there on the screen. So as you mentioned, this is really the biggest annual event for WIPO, where all of the 194 member states convene. And really, this is where the most critical decisions of the organization are made. Member states also use this as an opportunity to voice what their priorities are. And this is done in a lot of the opening statements, the general statements that the countries make, as well as really throughout the course of the 2 weeks of meetings. And the most recent assemblies took place in early to mid-July over the course of 2 weeks. And so throughout that meeting, member states undertake discussions and make key decisions really on all of WIPO's work streams. This provides direction to WIPO's work, including the work of the various committees throughout the course of the year. Something else that's important to highlight is that, we talk about member states coming together, but also accredited observers participate in these assemblies. And they're really, they add a lot of value, and they're really helpful to hear the voices of stakeholders. And observers are essentially stakeholders that apply for and are granted accreditation by the WIPO assemblies, and they can deliver remarks at the assemblies on the various agenda items. And there are already 400 accredited observers at WIPO, and this includes intergovernmental organizations, as well as non-governmental organizations such as the American IP Law Association, the Chamber of Commerce of the United States, as well as the International Chamber of Commerce. And as I mentioned, observers are able to participate in the assemblies and deliver statements really on most of the agenda items. And we really strongly encourage U.S. IP rights holders to become active at WIPO, including as observers.
Thanks, Laura. And I'll just highlight that to prepare for such a meeting where you're covering essentially all the topics at WIPO, taking decisions, being prepared for new topics to come up. It took the entire team here and many who aren't here, obviously a tremendous amount of work, and also very appreciative our team was of stakeholder input, which is critical for informing our positions to make sure we're advancing U.S. interests in the best we can. And with that thought, I'm going to pass it back to Mary.
Thanks so much, Dave, Andrew, and Laura. And Laura, thanks for highlighting, the really robust process that we have at WIPO. I mean, it's not just us doing the work, as Dave mentioned. We spend a lot of time all year representing the U.S. government at different committees at WIPO. But it's such an elaborate process. But as Dave and Laura highlighted, we wanted to also just say that when we're developing these positions, you heard a little bit about what OPIA does and how we represent the U.S. government at WIPO, but in formulating these positions and developing our thoughts and our views and our interventions, it's so critical to hear from your stakeholders. So we really want to take this opportunity to highlight how valuable your input is. So if you do have any questions or you want to reach out to any members of our team, we have a general IP policy address. So please reach out to us at ip.policy@uspto.gov. We're happy to hear your input. And matter of fact, we really value your input, and we love opportunities to speak with our stakeholders about any concerns they have domestically as well as internationally. As I mentioned earlier on in the beginning of the presentation, that we've helped over 6,500 stakeholders last year, and we continue to do that. So please don't hesitate to reach out to us. So I'm going to ask those questions from the audience. Can you highlight any significant developments in the PCT working group? I know Gordon's a part of that working group, so maybe he can share some of the latest developments.
Absolutely, and thank you, Mary. and it's actually just always a delight to be on a panel with everybody here. I want to just take a step back and just talk about some of these working groups, because although you mentioned that I do represent, I go to the PCT working group and I go to the Hague working group, the people who participate in these meetings are not necessarily up here on this panel, and we pull from expertise from across OPIA, but also across the USPTO. So we obviously work very closely with our colleagues and the PC in patents on the PCT working group and the Hague working group, and likewise Madrid works with their colleagues at the within trademarks. So the PCT working group meets once a year, and again talks about what I'll say. It's a very mature system at this point. So it talks about very technical, sort of refining. We're in the fine grit sandpaper here, where we're talking about things like email addresses. We're talking about obviously bigger issues that would come up that would affect rule changes. But even if you look at the rules of the PCT, they're so much they're much larger than the rules of the Hague system. And so the developments of the PCT working group, we met last February, and there was the biggest development, frankly, was that the meeting was suspended indefinitely over the incorporation of the GRATK treaty into the PCT system. There was a dispute amongst the member states as to whether to even discuss this issue, whether it was premature, because again, the GRATK treaty is not in force, and so we expect that and other issues to keep coming up. But if you are interested in the PCT working group, it's WIPO has a very nice webpage that you can find each of the working groups, not just the PCT working group, but each of the working groups and what the agendas were, what the summary of the chairs were. You can watch the videos, and then you can see what happens then is that the working groups themselves only make recommendations, and it's the unions at the assemblies that adopt or don't adopt, but primarily adopt the recommendations of these working groups.
Thanks, Gordon. I see there's also a corollary question about this PCT footnote that you mentioned earlier. Does it have any weight in the PCT treaty, even if the GRTK treaty is not in force? It's an interesting legal question.
It is an interesting
legal
legal
question.
question.
Chime in on that one.
Why
Sure.
don't you
Well,
take that,
I think
Dave?
this comes back to the bodies we talked about. So there's a PCT union who makes decisions on the PCT. So it's that body that would take any decision. So if another body of WIPO, theoretically, they wouldn't have jurisdiction to, for example, if the GRATK treaty came into force, there presumably would be a union that governs that developments of that treaty. So in this case, the simple answer is whatever the PCT union decides is what would go into and that's composed of members of the PCT, because membership in these unions is not the same. Not everyone is a member of every treaty, and so only those that are bound by those obligations are the ones who are deciding the obligations.
And just one thing to add is that although this question is asking about a footnote, there are two footnotes, and so there's an article, and so the treaty can't be isolated just down to the language that's recited in just a single footnote. So. Yeah.
And I think Dave makes an excellent point that the PCT is a separate group, and therefore it's not bound to what's happened in the GRATK treaty, especially because there's different membership. So I think we are running out of time. Again, I just wanted to say thanks for participating, and please don't hesitate to reach out to us in the future. Thank you all to the panelists here today.
Thank you.
Thank you, Mary.